Council 1 will be dealing with issue number first and second for 10 minutes, and my rest of the issue will be dealt by my co-counsel for 10 minutes. The council seeks permission to begin with the statement of fact.
Yes, yes.
Much obliged, Lordship. Bhagya Vihari Ji temple in Vrindavan attract over 50 lakh devotees annually, and the area has narrow lanes, heritage structure, and fragile infrastructure. On August 19, 2022, during Mangla Aarti on Janmashtami, is stipulated occurred, causing 2 deaths and injuries to more than 25 devotees. On March 2023, Allahabad High Court directed implementation of a large temple corridor project involving demonetization for more than 300 structure equitization of 8 acres. At that point, appellant contacted project will evict more than 200 families and displace 500 business and irreversibly damage Vrindavan cultural heritage. The site lies within 300 to 500 meter of the Yamuna floodplain. No environment impact assessment or clearance obtained under the environment laws. Project area falls within the heritage zone. No approval taken under the Asian Monument and Ecological Sites and Remains Act 1958. Acquisition violates Article 300A of the Constitution of India and the Land Acquisition Act 2000.
Just a second. What do you mean by Article 300A?
Kindly grant me 2 minutes.
Please.
Article 300A clearly deals with right to property, person not to deprive to property save by the authority of law. In this case, the mentioned article
is a fundamental right or a legal right? Article 300A.
It's a legal right or constitutional right.
Okay.
May I proceed further, Lordship?
Yes, please.
State has already spent over 300 crores and yet proceed without environment heritage or public hearing clearance. Appellant filed a modification in April 2024 seeking to hold acquisition under due process is followed. So now the Supreme Court has referred the matter to 5-judge constitutional bench and constitute a high-powered committee. If the bench is satisfied with the statement of fact, the council seeks permission to further deal with jurisdiction of the case.
Yes, sure.
The jurisdiction of the case. The council is presenting the case on the behalf of petitioner, hereby humbly submitted that the Supreme Court under Article 32 of the Constitution of India against the judgment of Allahabad High Court. Article 32 of Constitution, remedies for enforcement of right inferred by this part. The right to move to Supreme Court by appropriate proceeding for the enforcement of right conferred by the part in guarantee. If the bench is satisfied with the jurisdiction, the council would like to further proceed with the issue number first.
Please.
Much obliged, Lordship. The issue number first before the bench is whether the High Court mandamus under Article 226 directly a particular corridor scheme amounts to impermissible micromanagement of executed policy or is a constitutional validity exercise to remedy systematical failure, endanger life and safety. It's humbly submitted before the court that while exercising power under Article 226 of the Constitution, its constitutional jurisdiction by prescribing a specific corridor scheme, do the High Court empowered to issue writs to secure fundamental rights of the citizen, ensure executive authority, discharge their authority, it cannot substitute itself for executive and delayed policy choices. One of the basic features of our constitution is doctrine of separation of power. In this, the judiciary cannot step into the matter of executive and legislative as there is a basic principle of power of review or there is basic principle of power of separation. High Court is empowered by the Article 226 of the Constitution to issue writs. There are 5 writs basically, and order and writ to enforce fundamental rights and other legal rights. And the right to property is legal right under the Constitution of India. Still, the High Court is not empowered to design or impose a particular infrastructure project as it is the exclusively domain to the executive, which has necessary expertise and democratic accountability. In several cases, the Supreme Court has counsel in several cases, as the case Aravali Golf Club and Chader, yes, which was mentioned on the page number 18 of our memorandum. In this case, it was held that the government should not be run by the courts. Judges cannot become the planner and the policy maker, but may review it legally. The court has power of judicial review. May I further proceed?
Yes, please. You can come on to the second issue, please.
Much obliged. May I refer some cases on this point? In the case of Common Clause versus Union of India, that was mentioned on the page number 19 of our memorandum, it was held that court must refrain from entering the executive domain. And also in the case of Supreme Court Employee Welfare versus Union of India, it was held that court cannot direct the framing of particular policies. According to these judgments, it is respectfully submitted that court may ensure compliance with law. They cannot substitute their own judgment for the exercise of executive. Therefore, this is most humbly submitted before the Honorable Court that the High Court mandamus amount to unconstitutional judicial overreach, violating the doctrine of separation of power, and ought to be set aside impermissional micromanagement of executive powers.
You please tell me Article 25 and 26, what does that mean exactly?
Article
in
20.
Layman language. In layman language, in normal sense.
Article 25 clearly deal with freedom to practice, and 26 clearly deal with management of religious affairs. And in the issue number 2, I am further dealing with these articles as the scope of Article 25 and 26. It is mentioned in Article 25 that every individual have freedom to concise and right to freely profess, practice, and propagate religion. It has choice of citizen. The right of religious to manage their own affairs in the matter of religious is protected under Article 26 of the Constitution. Faithful facilitation versus interference. The state from managing environment arrangements that facilitate safe worship, example, sanitation, crowd controls, and barricades, etc. It is not prevented by the Constitution. However, when facilitation becomes interference, the line is crossed. Measures that help the devotee to perform their rituals more safely without destroying the essential religion character are called faithful facilitation. Example, they can provide medical aid services, CCTV monitoring, and entry points and exit point, also a time for entry or exit points. Then
okay,
application.
Now come to third issue with the Article 21 one.
Lordship, further issue will be dealt with by co-counsel.
So we can proceed with the next answer.
Okay. It was indeed my honor to proceed before you, honorable bench. May I call my counsel number 2 for further issues?
The council seeks permission to resume the proceedings and initiate issue 3. Much obliged. Whether the state's objectives of crowd management and public safety under Article 21 justify large-scale demolition and redesign of an organically evolved sacred precinct, when less restrictive alternatives like staggered darshan, tech-enabled flow, festival time regulations may exist. It is humbly submitted before this honorable court that while public safety under Article 21 is a legitimate aim, the large-scale demolition and redesign of Vrindavan's sacred precinct is disproportionate and unjustifiable, when less restrictive alternatives are also available. I start with first proportionality as the governing test. The council refers the case of Modern Dental College versus State of Madhya Pradesh. It was well settled that whenever the state seeks to regulate or restrict the fundamental rights, it must pass the test of proportionality. The legitimate objective, sustainable adopted means to achieve the objective, necessary restrictions, and least restrictive alternative, and proper balance between the objective pursued and the rights infringed are required in the test. As under Article 21, the safety of the public is undoubtedly a legitimate aim. In the manner which it is pursued must still respect the equally significant fundamental rights of the worshippers and the residents under Article 25 and 26. Secondly, failure to adopt less restrictive alternatives. The most intrusive possible measures are demolition of over 300 structures, displacement of local residents, and redesign of an 8-acre precinct. This amounts to irreversible alteration of the Vrindavan sacred geography. Practical alternatives are already tested in other pilgrimage sites. For example, Tirupati Balaji Temple that manages lakh of pilgrims daily through online booking, staggered darshan slots, and digitally monitoring. Second, Shridi Sai Baba Temple that employs controlled entry passes, CCTV surveillance, and seasonable regulations. The failure of the state to even pilot such less restrictive measures before opting for permanent demolition is an indicator of arbitrariness. Next, disproportionate cultural and heritage loss. Vrindavan is not simply a physical locality, but a living religious ecosystem that has evolved organically over centuries. Large-scale redesign would sterilize this environment by replacing living heritage with a homogeneous tourist complex. The council refers case of Intellectuals Forum versus State of Andhra Pradesh. The Supreme Court emphasized that the need to balance development with protection of cultural and environmental assets. Here, the irreversible heritage loss far or outweighs the alleged gain in safety. As Article 21 protects dignity and not just safety. In the case of
To issue
Francis
number 4 now,
Ferrari versus
you can come to issue number 4 now, the Article 14(1). Just tell me that the people who were living there was consulted before the demolition drive or not, according to the Moot position.
Sir, they were consulted, but they are not satisfied with that
Okay.
because the right of heritage they are expecting to.
Okay.
Sir, the council seek permission to start issue number 4. Whether the absence or inadequacy of meaningful public consultations like residents, shopkeepers, religious bodies, environmental experts renders the decision-making process arbitrary under Article 14. The state from acting arbitrarily is prohibited in Article 14. The Council refers the case of E.P. Rayappa versus State of Tamil Nadu. The Supreme Court held that the arbitrariness and equality are sworn enemies. The failure to engage in meaningful consultation that reflects arbitrariness and violates Article 14. The state action affects the fundamental rights and livelihood, as decision making must follow fairness, reasonableness, and transparency. Secondly, participatory governance as a constitutional value. As Council refer a case of Welfare Forum versus Union of India and other environmental cases, it was held that the stakeholder input is essential before the projects altering ecology or proceeding the heritage. Public notices were also failed to reach the affected community. Neither the residents, nor the shopkeepers, nor the temple trust, nor environmental experts were consulted adequately. Thirdly, President of
Who were not consulted?
the shopkeepers or temple trust.
Okay. The temple trust people.
Yes.
Okay.
Thirdly, President of mandatory consultation and impact assessment. The changes like displacement or ecological change involved in party projects. The council refers the case of Narmada Bachao Andolan versus Union of India. The Supreme Court insisted on social impact assessment (SIA) and environmental impact assessments (EIA). This procedural shortcoming renders the decision void for non-application of mind, as though massively disruptive. The present project is proceeded without proper SIA and EIA. The legitimate expectation of participation. When the state action directly affects their interest, the doctrine of legitimate expectation protects the individuals is that right to fair treatment. In the case of Navjyoti Group Housing Society versus Union of India, the court held that departure from legitimate expectation without consultation violates the fairness. By excluding the consultation and pass the decision without their sacred voices, the local community of Vrindavan had a legitimate expectation that decision about their boundaries would invoke their voices. Lastly, the democratic legitimacy is lost by the project without the involvement of the stakeholders. The test of public legitimacy should be passed by the large-scale projects that involve cultural and religious boundaries. The absence of public hearings, lack of environmental studies, and failure to disclose master plans highlights the absence of transparency, a hallmark of arbitrariness. Therefore, it is respectfully submitted before this honorable court that the absence of meaningful consultation violates Article 14 and renders the decision arbitrary, unfair, and unconstitutional.
Okay, just tell me that protecting the old monuments like temple, etc., who is responsible, the court or the government? The government should take a reasonable step or what?
Sir, the government should take reasonable.
So now we can shift to the state arguments.
Greetings to the bench. I am audible. Hello, I am audible.
Yes.
Okay. Greetings to the bench. I am appearing on behalf of the respondent state. If my lordship permit, may I state the facts or move to the direct issues?
Yes, please.
Okay. Lordship, may I permit to state the facts or issues?
No, just come to the issue.
Okay. Issue number 1, whether the High Court's mandamus under Article 226 directing a particular corridor scheme amounts to impermissible micromanagement or executive policy, or is a constitutionally valid exercise to remedy systematic failure endangering life and safety. Now my arguments, may I state my arguments?
Yes, please.
Okay. Obliged, my lord. The Allahabad High Court's mandamus is neither unconstitutional nor judicial overreach. It is valid and proportionate exercise of powers under Article 226, complied by the extraordinary circumstances where systematically failure endangered human lives. The Baki Bihari Temple stampede 2022 was not an accident but a result of long-standing administrative paralysis. Narrow lanes, uncontrolled crowd surges, and lack of medical facilities created a recurring hazard. A writ of mandamus may be defined as a command issued by the Honorable Court to state or its authorities requiring the performance of a particular duty specified, which may result from the official duty or by operation of law. If my lordship may permit, may I state
please.
the part of High Court?
Yes.
Okay. The stampede was proof of systematic failure. On 2022, stampede was not an isolated mishap but clear proof of systematic failure. The Baki Bihariji temple is located in narrow, originally developed lanes designed centuries ago for local devotees, not for the lack of pilgrims, but who now arrive daily, swelling to millions during festival. The Baki Bihariji temple was constructed in 1864. At that time, when Vrinda was a small village town with a limited local population, and only seasonal influx of devotees were coming there. The temple precinct and its adjoining lanes were never designed to handle the scale of modern technical devotees pilgrimages. At that time, darshan was sought with the patience and deviation, and the physical presence on the site was minimal. But today, there are very serious issues of the crowd management beside provision for basic amenities for the devotee in around the temple. This 162 years temple is spread over 1200 square feet. Only an average number of devotees who visit temple 40 to 50,000 per day, and during the weekends and some holidays the number goes beyond 1.5 lakh to 2.5 lakh per day. During festival auspicious days such as Janmashtami, Raksha Bandhan, Sharad Purnima, etc., the number surges to 5 lakhs of devotees in a single day. The narrow heritage lanes are insufficient for the small pilgrims to handle this type of number of the devotees. If my lordship may permits, please see the page number 18.
Yes.
The chart, my lordship, this chart demonstrates the actual volume of devotees visiting Baki Bihari temple daily and during festival based on verified records from temple authorities. It shows pressure on existing narrow lanes, alleys, and circulation paths. We submit this to illustrate the context for the redevelopment project, not to direct policy, merely to provide factual grounding for the state permitting consideration. To state that on the regular days, Monday, Tuesday, Wednesday, Friday, the peoples come within the 20,000 to 50,000 per lakh. And Saturday, Sunday, which is the holidays, the people will starting from the 250. And we submit that on the Janmashtami, Sharad Purnima, Holi, and Radha Ashtami, the peoples are coming in a per day 6 lakh to 7 lakh devotees. Across India, many small religious towns, originally built for limited local population, have had to undertake large-scale redevelopment projects because of modern crowd pressures. In Varanasi, the Kashi Vishwanath project widened narrow lanes, created regulatory and exit gates, and added medical and security facilities to handle. The project protects Article 21 rights. The right to life under Article 21 is the most important constitutional rights. It includes not just living, but living safety with dignity. The lanes and streets around the Baki Bihari temple are very narrow, and the old structure cannot handle the huge number of pilgrims. The stampede on 19 August 2022, which killed 2 people and injured 25, shows that the risk to life is real and can happen again in the future because of the increasing devotees day by day. Now, every festival, devotees and local residents face the danger of overcrowding. The corridor project with wider pathways, controlled entry and exits, holding areas and medical security facilities, not just a fancy development. It is essential to protect human life. Without it, the state would fail to safeguard the right to life under Article 21. If my lordship may permit, may I state the issue number 2?
Yes, yes.
Whether the reconfiguration of temple approaches alleys and religious routes indicates Article 25 and 26, and if so, that contract has to distinguish faithful facilitation from unconstitutional interference. The reconfiguration of temple approaches alleys and circulation routes does not violate Article 25 and 26 of the Constitution. It actively protects the religious rights. These articles guarantee 25 and 26 every person the freedom to practice and manage their religion, but this freedom has only meaning if devotees can safely access the place of worship. Large crowds during festivals, narrow alleys, and congested approaches create serious risk, like including stampede, injuries and chores when directly threaten the enjoyment of religious freedom. The corridor project addresses the problems in the multiple ways. Firstly, widening lanes and controlled entry-exit points. By recognizing the movement of devotees, the project prevents overcrowding in critical areas, ensuring that everyone can move smoothly to the sanctum without risk of stampede or pushing. Essential facilities like toilets, cloakroom.
Now we will skip to issue number 3. Before that, just tell me that did you consider any safe and the smaller alternative to the people residing there?
Sorry, Lordships, I am not audible.
I'm saying that under Article 14 that you were talking about, sorry, Article 21. So, like, did you consider any alternative to the people residing over there?
No, Lordship, I have taken the reasonable classification as in class legislation, which state that one can be taken over the another group. If one group is satisfied, their rights are not violating, then we can take over the another group, because there are not only about the violation of the fundamental duties of the person, but here are the protection for the peoples who are coming daily on the basis. We can see in the chart that the persons are devotees are coming regularly on the basis of lakhs numbers of. We cannot cover the only the persons of the fundamental duties over the violation of that person. And we have, and itself they have stated, speaker number 2 itself stated that we have taken their hearing, and they are not satisfied with that, but we have taken their hearings. We have there because there is no violation of Article 300A. If my lordship may permit, we move to the next issue.
Yes, yes.
Okay, my next issue will be deal with my sister council, speaker number 2. Thank you, lordship.
Greetings to the bench. May I please to the Honorable Court, having heard my sister counsel, I shall address the next issue.
Please.
May I state the issue, Lordship?
Yes, yes. Please start.
Issue number 3, page number 24 of my memorial, whether the state
No,
object.
don't read, come to the issue.
I'm just reading the issue.
No, don't read it. You can justify your point.
Okay, sir.
Hmm.
So first point is permission from the honorable. It is the most respectfully submitted temporary fixes like staggered darshan tokens or festival policing are band-aid solution, not the permanent ones. We need a permanent solution for this problem. So first, why temporary measures are not enough? Crowd surge, crowd surges are too big. On normal days, 40 to 50,000 pilgrims visit on the festivals, up to 5 lakh in one day. Token symbols, barricades, and staggered darshan kelpers under crowd pressure and emotional surges. Third, the 2022 Banke Bihari stampede occurred despite police and barricades. So we need the permanent solution. Second, technology cannot control the crowd because digital tokens or apps cannot cover many pilgrims who are not tech savvy. Internet failures or technical issues cause panic. Authorities cannot deny entry on tech grounds. Festival time policing is temporary. Extra police and barricades are developed only on major festival days. Crowd pressure is daily, not just on festivals. These reactive measures do not prevent accidents in advance. No space for rescue in present setup. Extremely narrow lanes prevent ambulance or fire brigades access in emergencies. Temporary fixes do not solve the permanent constraint. So now why the corridor project is needed? A current temple lanes make safe darshan nearly impossible. Temporary measures have failed, necessitating a long-term structural redesign. Wider entry and exit routes are needed. Current narrow lanes for entry and exit through the same path, causing the dangerous crowding. One-way circulation through the separate gates is internationally recognized for crowd safety. Example, Kumbh Mela. Holding areas and waiting zones are essential. Present queues are cramped LAs leading to the panic. Batch management in courtyard-style waiting areas like Vaishno Devi can regulate crowds safely. Emergency medical services are vital. Fast deaths occur due to medical inaccessibility. The project must include medical rooms, oxygen points, fire exits, and on-standby medical staff. May I seek permission from the honorable bench to state the next issue?
Yes.
Uh,
Just do it in a brief manner, in a short one.
okay, sir. The corridor project consultation focuses on the public safety and welfare, not personal profits. The state provides full compensation and rehabilitation to the shopkeepers' families and ensure prevention of religious heritages.
How much compensation are you granting to them?
The compensation which they need, like if they are, they are facing problems under a limited area. Like if we talk about shopkeepers, they are, facing the problems of 3 to 4 thousand every day. Now the government will give them another place to do their business so that they can compensate them behalf of the
Do you
heritage.
think that the compensation is a fair decision by the government? By
Yes,
displacing?
yes, my lordship. Because if we can't give compensation to the government, this will be, very bad thing to the accused ones.
Okay.
May I continue?
Yes, please go ahead.
The project does not violate Article 14, which forbids arbitrary state actions but doesn't require mass consultation. Courts uphold policies that are fair, reasonable, and rational. Meaningful consultation occurred with experts like Archaeological Survey of India, police and temple trustees. Article 14 demands fairness, not perfect procedure, and consultations prove non-arbitration. Urgent public safety needs justified limited consultation to prevent further stampedes and losses of the lives, prioritizing public welfare. Salus populi, Supreme Lex Esto. Judicial precedents like Rajiv Suri versus DDA uphold expert-based project despite limited public participation as long as the policy is rational and not arbitrary. May I seek permission from the Honorable Court to state the prayer?
Please.
In light of the issues raised, arguments advanced, and authorities cited, the respondents pray before the Honorable Court that it is pleased to first dismiss the petition filed by the petitioners as not maintainable as they have failed to establish proper standing and cannot show any real violation of law or constitutional provision. Second, uphold the decision of the state implementing the Vrindavan Corridor project, nothing that all actions include consultation with residents, shopkeepers, religious authorities, and technical experts have been carried out purely for public safety and convenience and not for the benefit of any individual private interest. Third, confirm the rehabilitation and compensation measures offered to affected shopkeepers, families, and devotees are adequate, fair, and reasonable, and that the heritage of the temples have been preserved with only minor improvements for safely aesthetics and crowd management. Fourth, recognize the project is urgently necessary to prevent stampedes, ensure smooth darshan, and protect devotees, lives in line with Article 14 and 21 of the Constitution, and or fifth, pass such other orders as Honorable Court may deem just proper and necessary in. May I rest the case, Honorable
Yes.
Lordship?
Now coming to the petitioner side, can you please also tell me of what is your prayer?
Yes.
Please.
Wherefore, in the light of the facts presented, issues raised, arguments advanced, and authorities cited, it is humbly prayed by the appellants before the Honorable Court to first set aside the judgment of the Honorable Allahabad High Court directing execution of the Banke Bihari Corridor Temple project. Second, declare that the said project is violative of Articles 14, 21, 25, 26, and 300A of the Constitution of India. Third, direct the respondents to explore the adopt less intrusive and heritage-sensitive measures for ensuring crowd safety. Fourth, restrain the respondents from further demolition, acquisition, or construction until due process, environmental clearance, and heritage safeguards are complied. And fifth, pass any such orders or directions that this honorable court may deem fit and proper in the interest of justice. And for this act of kindness, the appellants as in duty bound shall
Yes, so you
every
can come now to the rebuttal.
If my lordships may permit, may I start with the
Sorry?
for the rebuttal issues?
Yes.
Okay. First of all, lordships, they have put the jurisdiction under Article 32. They have filed the case under Article 32. What are the fundamental rights? They have mixed up the fundamental rights and non-fundamental rights. First of all, violations of Article 14, 21, 25, and 26 are the fundamental rights which guaranteed rights under the Part 3 of the Constitution, Article number 12 to 35. But they are directly enforceable in nature in Supreme Court under Article 32. But they have taken the article number 300 as a legal right. They have stated themselves non-fundamental rights are outside part 3, which are not enforceable under article 32, and no person shall be deprived of his property save by authority of law. It itself said by article 300A. After 44 constitutional amendment, property was removed from the fundamental rights. Another, the appellant says he is filing the article under 32, stating that they are against the executive order of the Allahabad High Court. They have said the Allahabad High Court does not have right to issue the mandamus for the executive order of the redevelopment project, but they are failed to do that because their jurisdiction come under the Article 137 SLP, which directly states the jurisdiction of the appellates against the Allahabad High Court or any High Court, which they can directly go through the order of their degree of the judgment.
Okay.
Another lordship, Another lordship, if you please refer the page number 23,
Hmm.
page number 23 of their memorandum. From the top lines, they have stated the case Ismail Faruqi versus Union of India, which clearly says places of worship can be undergo regulation and redevelopment without altering core religious character. Under section 92 of the Indian Trust Act, which states that this case is not be reliable here because we are not changing any religious activities like no aarti, no bhog, no seva. We are only protecting an administrative feature. We are only creating the crowd management better for the better experience of darshan. We are not taking these cases like reliable for this because we are not changing any religious activities. We are only protecting the safer experiences for the pilgrims and for the development of the devotees which will be coming in the future as well as nowadays.
So are
So
you
this
doing it with
development
the
project
expert
is
approval or
essential for
not?
that.
Are you doing this like creating a
What?
corridor with the expert approval or not?
Lordships, in our PA, it was stated clearly that we will seek permissions from the everyone. We will go with the
Okay.
authorities. We will take their schemes, policies. Yes,
That is what I want.
published.
Okay.
Yes, Lordship. Pardon me. The project does not transfer ownership only. It enhances the management for new redevelopment project. It does not interfere with the rituals or worship process, Lordship.
Okay.
If my Lordship may permits, I rest the case.
Please. Thank you. Yes, anyone from the petitioner side?
Council seeks permission to give the answer to the respondents.
Please.
As per Article 14, it is the article equality before law. Everyone is equal before law, either it is devotees or either is the shopkeeper. There was the rights infringed for the shopkeeper because they don't get adequate compensation. The adequate compensation is not mentioned. Also, every person has right to life. If the shops of shopkeeper are taken away for the corridor project, which was violation of the right to life. And Article 308 clearly states right to property, which is, as per the new amendments, it is not a fundamental right, it's a constitutional right or a legal right. But if the property, it is the right of the human being to keep the property. Also, if the shops of the shopkeeper are taken away for the corridor protect, the legal right of the shopkeeper has also been infringed. Also, the second rebuttal question was, in the case respondent is the case is Aslam Faruqi versus Union of India, that was cited on the page number 23 of our memorandum. In this case, the court held that places of worship may be regulated and their essential religion character cannot be alterated by the state, because every human being has right to pray for their culture or religion. If the bench is satisfied.
Yes.
Lordship, that is herself stated that this case is for alternative of the for their culture, but we are not talking about the culture. We are here for the betterment of the devotees and the pilgrims. We are here for the safety of their future, when the devotees will come, pilgrims will come in the future, for their better experience of darshan. We are here. We are not stating that these case laws are not liable here. We are stating that this is not for the culture alternative. We are not doing culture relative. Alternatives means that the religious activities are to be involved in that case. Here, no religious
But
perspective
you have
has
not
been taken from
told
our
them the exact amount of compensation that you will be granting them.
May I ask some rebuttal questions from the respondent, if the bench give me permission?
Please.
If Article 25 ensure meaningful worship, then how can devotees exercise that right now when Laro Knowles put their lives at risk? And the next, can technology or online booking realistically control 5 lakh privileges on the special occasion, that is Janmashtami, Holi, and other that was mentioned in the Moot preposition? when the state has provided rehabilitation and compensation and consulted expert included ASI and temple authority, how the decision making arbitrary under Article 14? I have done with my questions.
Yes, please.
Lordship, may I state that they have stated the example Jagannath Temple, Shirdi and Tirupati Balaji. But Jagannath Temple was constructed in Odisha Puri, first old temple, which was 4.25 lakhs square feet meter. But our Baki Bihariji temple is only 1200 square meter, where the Shirdi temple was also in the lakh square meter. There the crowd management was made in that place, that there was a land which was occurring the space to make the new developments in itself that temple. But here the Baki Bihariji temple is itself small, that we cannot change the developments in itself the temple, because it's only 1200 square meter. Because they have taken the example Jagannath temple and they are stating that corridor demonstration and distribution hard data. But we are not stating that. We are explaining safety risk proven by stampede dates, heritage loss, speculative. Here the temple will not change the culture and heritage. We will only be make the betterment for their safer darshan and experience.
And their argument is that via electronic mode, can you handle 5 lakh pilgrimage?
Yes, Lordship, we are making this corridor redevelopment project within the 3000 square feet, where we will make different kinds of rooms like crowd management room, staff room, restroom, toilets. So the person which are going through the same place will not be arrived from the same place. We will make exit doors and outdoor doors, which are also made in the Jagannath temple. 4 gates are made in the Jagannath temple itself, Lordship, which does not include the persons in the same place. They are all in the different gates, so their crowd management is less. In our pilgrims, where we are increasing that by day, so we are explaining that this redevelopment project will not only give safety, but also will less increase the crowd management, because the children and disabled women who are suffering because there is no toilet, there is no crowd management room, so they can go there and then crowd will be less. So there will be no crowd management, no stampede will be happen in the future.
Okay. Anything else? Or should we conclude now?
I think we are good to go.
Yeah, okay.
Congratulate you all. Congratulations. It was wonderful, wonderful, wonderful rebuttals and but
You all were very good.
yes. But I heard it clearly, every point of argument, every point of arguing the argument again from the respondent and the plaintiff side. It was mind-blowing, mind-blowing. Good. Congratulations to all the participants here. I now
And please
request the
don't
Lordship.
mind with the marks that I will be giving to you, because everyone are, on their good part only. Please. Thank you so
You
much.
guys made my day. It was very good,
Yes.
very good, good. So, Lordship, I now request if you can provide your valuable feedback to the participants or the councils.
Yes,
It is much needed.
yes, actually, as I said that you all were amazing. Can I get to know in which year all you are?
Lordship, I am in second year of law. In 3 years LLB.
And you are doing a 5-year course or 3-year course?
No, 3 years course.
3 years course. And everyone else, like
I'm in third semester, Lordship.
third semester. So yours is also 3-year course?
Yeah, 5th year course.
5-year.
Integrated course, Lordship.
Just I want to keep it very short that after this Moot competition in which you will be participating, just keep all the issues very small. Don't read what is being presented in the Moot competition, sorry, the Moot proposition. Just come to the issue. Keep it small, keep it to the argument point of only. Don't, read all the judgments. You can tell me in the short that what does that exactly mean. You can come to the ratio decidendi of it. What is the outcome? What is like if there's any judgment of High Court, so whether it was challenged to the Supreme Court or not, this kind of a thing. So yeah, everything was amazing. And I never participated in the Moot competition when I was in college. And when I go to the courts, I think that I should have. But seeing this such kind of a confidence is like really amazing. So you all were good. So that is why I'm saying that please don't mind what marks that I will be giving to you all. I have to make either of you win for the next round. So you all were amazing. All the best and congratulations for your future course of action. Thank you.
Thank you, Lordships.